I'm Ann Beeson. I'm the Executive Director of U.S. Programs at the Open Society Institute, and I welcome you all here to this, what I hope will be a lively discussion about material support laws and their impact on First Amendment rights. I feel a little bit like this is one of those wonky plenaries, so we have that particularly wonky law students that decided to come to it. But as you will see, even though it's a very complicated legal issue, it has very real and very serious implications for real people's lives. And you're going to hear more about that this morning. My job is just to moderate this group of stellar experts on the subject up here, and I want to first introduce them and then just give a little bit of context about the laws we're going to be discussing, and maybe just a little bit about the current advocacy efforts around those laws. My connection to the issue, I suppose, is twofold. One, I used to be the associate legal director at the ACLU, and we litigated as amici in a number of these cases, and also I have the honor of supporting a number of the organizations that have been advocating to reform these laws. So I want to just say that to disclose right off the bat that I'm not one of those objective moderators, although I'm going to try to serve in that role today. We have with us some fantastic lawyers, many of whom I'm sure you all know and who have been regular participants at the American Constitution Society events every year. First of all, to my immediate left, David Cole, who of course is a professor at Georgetown and who has just recently argued this spring the current case before the Supreme Court, the Humanitarian Law Project case, which challenges the material support provisions. David is the author of many books on the Constitution and a longtime constitutional litigator, and will be the real expert, I think, up here on the details of the law. I was a little bit concerned, and you probably were too, David, that the decision might come down yesterday. I was mainly concerned because then I would have had to read every word of it on the train down here from New York. But I think it would have probably compromised David's ability to be on the panel this morning if it had come down. So it did not yet come down. To David's left is Jeff Stone, an esteemed professor of law at the University of Chicago and author of a number of other very terrific books on the First Amendment and the Constitution generally, including most recently War and Liberty, An American Dilemma, and Top Secret, When the Government Keeps Us in the Dark. I'm still getting caught up. The last one I read was Perilous Times, Free Speech in Wartime. And then to Jeff's left is Akil Vora, who is the counsel to Muslim Advocates, a terrific organization that advocates on behalf of the Muslim community here in the United States. And Akil is leading their Muslim Charity Works campaign and is, I think, a real expert in the country on advising Muslim charities on how to avoid problems with laws like this and many other laws that infringe on due process and constitutional rights. And finally, to Akil's left is Ken Weinstein. Ken is currently a partner at O'Melveny & Myers, previously held a number of very important positions, including serving as President Bush's Homeland Security Advisor, leading the National Security Division as the Assistant Attorney General for National Security at the Justice Department, and many other positions. So with that, I want to just say a few words about these laws, and I say these laws. There is one particular law, which is now I'm going to do one of these things where I garble, as everybody else does, all the laws, which is a provision of the Anti-Terrorism and Effective Death Penalty Act. This is the provision that is at issue in the case that David is litigating. And there are also important provisions that restrict the provision of material support to terrorist groups that are in the International Emergency Economic Powers Act, otherwise known as IEPA, and also Executive Order 13224. So if you hear references to those, we'll kind of try to avoid them a little bit and just talk in terms of this range of laws that restrict material support to organizations designated by the federal government as terrorist organizations. These laws have been with us for a while. I think we'll probably get a little bit into the history of them. There have been challenges to them going back at least 20 years, and they have unsurprisingly gotten both more draconian in the last number of years and also have been used increasingly by the government. I think I read a statistic somewhere that over half of the government's terrorism cases, I'm sure Ken could correct me if I have this a little bit wrong, but over half of the government's terrorism cases involve prosecution under the material support provisions. Why does this issue matter? This issue matters because it is having a serious impact on the activities, not just of possible terrorists and their sympathizers, but also legitimate charities and humanitarian organizations and nonprofits that work here in the United States and also that work around the world in conflict zones, in disaster areas, et cetera. Just a very short list of the number of organizations that have been involved in advocating for reform of these laws. It includes the International Crisis Group, Oxfam, Human Rights Watch, the Carter Center. There were really a number of examples of specific kinds of aid, including the provision of legal service, the sending of doctors to disaster areas. The law exempts the provision of medicine, but makes it illegal to send the doctor, makes it illegal for the person who can get the pill, without running afoul of the law to use the water to drink the pill, and which also limits the actual peace and conflict resolution advice given by a number of international human rights organizations. And a number of these groups have talked about the impact of that these laws have on their work. Over the past number of years, organizations have gotten very specific in suggesting reforms for the law. Most specifically, and I'm sure, again, the panelists will talk a little bit more about this, the biggest problem is that the law does not require the government to prove specific intent to support the terrorist activity of the group. And that simple fix could resolve a lot of the problems. Also, the law contains a very narrow exemption for medicine and what's the other one I'm forgetting? Medicine and... Religious. Yes, religious, exactly. But not for humanitarian relief, as I said before, and again, writing in a specific broader exemption for humanitarian relief might solve some of the problems. So with that very brief introduction to the issue, I'm going to have each of the panelists talk for about 5 to 7 minutes, and we're going to try to hold them to the time, just give a little overview of their work on this issue and their position on it. And then we hope to have a bit of a lively dialogue up here. I've got some questions to ask the panelists, which we'll go back and forth on, and then, of course, we'll open it up with plenty of time left over for you all to ask questions. So with that, David.
Thank you, Ann. I actually would have loved the decision to come down yesterday, because then I wouldn't have to keep my fingers crossed and hold my breath for another week or so, and also because everything that we say this morning will become moot on Monday or Thursday or the following Monday when the Supreme Court renders its decision and tells us what we should think about this issue, or at least what 5 of them think about this issue. I think probably the best way to understand this whole set of material support laws is as essentially a kind of revival of the McCarthy-era tactics of guilt by association. When we fear the actions of individuals that we're not really able to identify with great precision, we tend to enact laws that allow the government very broad leeway to go after people who have not yet actually engaged in violent conduct, but who we fear might at some point engage in violent conduct. And so in the McCarthy era, we made it a crime to be associated with the Communist Party, to advocate various communist doctrines, not because the association and the speech itself was of concern, but because of the concern that it might lead to some illegal action on the part of the Communist Party. Well, similarly with respect to the material support law at issue in the Humanitarian Law Project case, the provision of medical assistance or of human rights training to an organization to try to encourage it, in the example of human rights training, to pursue its ends through lawful, nonviolent, peaceful ends. There's nothing wrong with that conduct in and of itself. It poses no threat to the United States. But by drawing the statute as broadly as Congress has done and as the administration has interpreted it, It gives the government the ability to target people, threaten them with conviction, obtain guilty pleas, and convict on quote-unquote terrorist charges without proving that an individual engaged in terrorist activity, that he conspired to engage in terrorist activity, that he aided or abetted terrorist activity, or that he ever intended to support terrorist activity of any kind. And the way it does that is essentially akin to the guilt by association principles of the McCarthy era. It makes it gives the government the power to proscribe groups, put groups on a no support list, and then criminalize any activity that is engaged in that might support that group. And the case before the Supreme Court challenges the breadth of the definition of the support which is criminalized by this statute. The statute includes within the definition of material support the provision of expert advice, the provision of training, the provision of services, which the government has said is anything done for the benefit of the group, and the provision of personnel, which the government says is anything done under the direction or control of the group. It requires, according to the government, no proof that the support itself furthers or is intended to further any sort of terrorist activity. And according to the government, it makes it a crime to write an amicus brief in the Supreme Court, to petition Congress for legal reform, to publish an op-ed in the New York Times, if done in conjunction with or for the benefit of a prescribed group. Our clients, a former administrative law judge, Ralph Ferdig, and the Humanitarian Law Project, a human rights group in Los Angeles, had been, before this law was enacted, working with the Kurds in Turkey, encouraging them to pursue their disputes with the Turkish government through lawful means by helping them in bringing human rights claims in Geneva, by helping them in peacemaking overtures with the Turkish government, by engaging in political advocacy on behalf of the human rights of the Kurds in conjunction with the Kurds' leading political representative, the Kurdistan Workers' Party. After this law was enacted and the Kurdistan Workers' Party was put on the do not support list, it became a crime, punishable by 15 years in prison, for them to continue to engage in this very activity. And so the case as it stands before the Supreme Court asks whether the government can criminalize such activity, pure speech, teaching somebody about human rights advocacy, advocating for reform in Congress, writing op-eds. Can the government criminalize pure speech, advocating lawful, nonviolent activity in the name of preventing support for terrorist groups? The general rule, as I'm sure everybody in this room knows, is that the government can't penalize speech even if it expressly advocates illegal activity, unless it meets the Brandenburg standard of intended and likely to incite imminent lawless action. Our clients don't even seek to advocate any sort of illegal activity, but only lawful, nonviolent activity. We've also argued, and we won on this ground below in the Ninth Circuit, that the provisions that we're challenging are unconstitutionally vague, that the provision, for example, on prohibiting expert advice, which is any advice derived from specialized knowledge, or training, which is any training in a specialized skill, these are vague because what the government says is you can meet with these groups, you can go over to Turkey and sit down with these groups, you can even join these groups, you can talk with these groups, but if in answering a question you happen to provide them any information that might be derived from specialized knowledge, or happen to impart any specific skill, or happen to do anything that might constitute a service because it's for their benefit, you are not subject to a 15-year criminal sanction. The government makes two basic arguments in defense of the statute. The first is that the statute prohibits conduct, not speech, because it also prohibits the provision of money and arms and things of that nature. Our response to that is that when you make it a crime to provide information in the form of words, you are criminalizing speech, not conduct. And the fact that you also criminalize conduct shouldn't permit the government to avoid the traditionally rigorous scrutiny that is applicable when the government regulates speech. The second argument the government makes is that all aid is fungible, and therefore every form of support needs to be prohibited in order to keep these groups from engaging in terrorism. Our response to that is it's hard to see how human rights training is fungible in the sense of could be used to further terrorist ends. And moreover, this argument proves too much because it was in fact the same argument that the United States made about the Communist Party during the Communist Party era cases. They said any support to the Communist Party, any association with the Communist Party will further its illegal ends because all support is fungible. The Supreme Court said, no, we're not going to let you penalize all support, only support which is specifically intended to further the illegal ends of the group. When I made that argument, quoting from the United States brief to the Supreme Court in the Scales case before the Supreme Court in February, Justice Scalia said, oh, well, that was the Communist Party. People joined the Communist Party for philosophical reasons. This is different. To which I said, I don't think that at the time anybody viewed the Communist Party as a philosophical debating society. And in fact, Congress made specific findings that the Communist Party was an international criminal conspiracy using terrorism with the aim of overthrowing the United States by force and violence. I don't think I convinced Justice Scalia. Why is this important? Two points on that, and then I'll close. One is that we are in what John Ashcroft called the paradigm of prevention, and it hasn't ended with the Bush administration. And at any time when the government is in a preventive paradigm, when its emphasis is on getting people before they do bad things, there will be this temptation to draft laws very broadly in order to permit us to get people before they've done illegal and actually harmful conduct. And so this is a key, probably the key statute in the criminal law that instantiates that approach to law enforcement. I think it's a very dangerous approach for the very reasons that we saw during the Communist Party era when thousands of people got implicated who were engaged in no harmful conduct whatsoever. The material support laws are the 21st century version of the guilt by association approach of the McCarthy era. And then secondly, I think as a doctrinal matter, purely as a doctrinal matter, if the government could prevail on this argument, which it made its central argument in the case, that it can criminalize pure speech as long as in the same statute it also criminalizes conduct, without having to meet the rigorous scrutiny that traditionally applies when the government criminalizes pure speech, that would have very, very broad implications for protection of speech across the board. Thank you very much.
So I'm going to pick up on what David said about the First Amendment issue in the case and explore that in a bit more detail. As you'll see, in my view of the matter, it's actually a fairly technical and complex question. So the statute, as Ann suggested, makes it a crime for anyone knowingly to provide material support to a terrorist organization. And it defines as material support any property, currency, lodging, training, expert advice, false documentation, facilities, equipment, weapons, transportation, and so on. And the issue is whether the statute violates the First Amendment insofar as it makes it a crime for anyone knowingly to provide training or expert advice to a terrorist organization as a form of material support. I want to put the vagueness and overbreadth issues aside and focus on the pure First Amendment issue that's posed by the case. Now, to state the issue clearly, let's assume the defendant is prosecuted under this statute for knowingly sending to a terrorist organization a book about how to raise money. Presumably, this would fall squarely within the statutory prohibition. Defendant claims that this act, on his part, is protected by the First Amendment and that the statute is therefore unconstitutional, at least as applied to him. As I said, this turns out to be more complicated than might at first blush appear. To begin with, suppose for the moment the defendant had been prosecuted under a statute that expressly declares it unlawful for any person to send a book about how to raise money to a terrorist organization. In that situation, the statute would clearly be directed at the content of speech, and it would be subject to a very high degree of scrutiny. Most likely, the government would have to prove the defendant had sent the book not only with knowledge that he was sending it to a terrorist organization, but also with the specific intent to facilitate that organization's terrorist activities. And even then, we might insist that, that the book, in fact, have a clear and present danger with respect to the ability of the organization to engage in illegal activities, or at least have some substantial effect along those lines. The statute, in other words, that I just hypothesized, would clearly violate the First Amendment. In HLP, however, the government argues that the statute at issue is in fact very different from the one I just hypothesized, because it is not expressly directed at the content of speech, and indeed, the government argues it's not even directed at speech as such. Rather, the government says the statute is directed at material support. And under the statute, it doesn't matter at all whether that support takes the form of providing weapons, providing cash, providing facilities, or providing advice. The law, the government argues, has only an incidental effect on speech. It's not directed at speech. So to support this position as a constitutional argument, the government invokes United States versus O'Brien, in which the court upheld the constitutionality of a statute prohibiting anyone knowingly to destroy a draft card as applied to an individual who burned his draft card at a public anti-war rally in order to express his opposition to the draft. The court upheld the conviction in O'Brien, holding that the statute had only an incidental effect on speech. That is, it was not directed at expression, but would have applied, in fact, to anyone who destroyed a draft card for any purpose, regardless of whether the destruction was meant to be expression. So if someone burned a draft card to light a fire in a fireplace, that too would violate the statute. So the statute was not directed at speech, it had only an incidental effect on it, because in that case, it happened that O'Brien burned the draft card at speech. But it wouldn't have mattered under the statute whether he burned it at speech or burned it to light a fire. This, in fact, is a general First Amendment principle. That is, it applies, for example, if someone steals a camera to make a movie and is prosecuted for theft. It applies if someone disturbs the peace by making a loud speech at night with a loudspeaker in a residential neighborhood and is prosecuted for making the speech. And it applies if an individual speeds on a highway in order to express his opposition to speed limits, and he's prosecuted for speeding. In each instance, the law against theft, the law against disturbing the peace, and the law against speeding is not directed at expression. The law has only an incidental effect on speech, and therefore, under O'Brien and settled doctrine, need not be tested by strict scrutiny or any other highly demanding standard of First Amendment review. The government argues in HLP that this is exactly what is at issue there. That is, the law prohibits material support, without regard to whether the support is in the form of guns, money, or advice. The law, therefore, has only an incidental effect on speech. In this case, should be governed by O'Brien, and since there's a reasonable justification for the law, that ends the First Amendment inquiry. The question then is whether there's any way to respond to that argument. Well, suppose a law prohibits any person to cause a breach of the peace. The law could constitutionally be applied to an individual who waves a gun around in a bar or who sets off firecrackers late at night in a residential area that angers his neighbors, or who parks his car and leaves it in the middle of Constitution Avenue. Those would all be easy examples. But suppose the government instead attempts to apply that statute to a speaker who advocates jihad and causes a hostile audience response. So there's a riot in response to the speaker. Is that a mere incidental effect of the breach of the peace statute that would be governed by O'Brien? In fact, in my view, the court will not treat that hypothetical under the O'Brien principle, because the key to the incidental effect doctrine is that what causes the harm that the government wants to prevent under that doctrine is not the content of the speech, but the very means of expression itself, independent of its expressive nature. So, for example, destroying a draft card interferes with the administration of the draft without regard to whether the act is expressive. Speeding is dangerous without regard to whether it is meant to convey a message. Loud noises disturb the peace without regard to whether they are in the form of political expression, music, or firecrackers. So in other words, two factors actually must be present for O'Brien to apply. First, the law must not be directed at speech on its face. But second, also, the harm caused by the act, that is the justification for prohibiting the act, must be independent of any message conveyed by the actor. If the reason for prohibiting the act is in fact directly tied to the speech element, then O'Brien does not apply, and we're back in the first framework. Now, Harry Calvin, my First Amendment teacher when I was a student at Chicago, always said that in its very essence, law is about choosing between competing analogies. The question in HLP is simple to state. Is the prohibition of giving expert advice under this statute more like the prohibition of speeding, as applied to someone who speeds in order to express his opposition to the draft, in order to express his opposition to speed limits, or is it more like the prohibition of causing a breach of the peace as applied to someone who causes a breach of the peace by expressing offensive ideas? Viewed in this way, HLP is not about any grand principle or First Amendment theory, but it poses a very difficult analytical question about the logical boundaries of two competing principles where they abut one another. Now, the good news about all this is that there's in fact an easy way to resolve this case. I believe, I'm always wrong about this, by the way, but nonetheless, I believe and I predict, and then I'll be 0 for 274, that the court will invalidate the statute on a ground that has nothing to do with anything, but picks up on the fact, as Ann pointed out, that it contains an exemption, a completely bizarre exemption, for religious material. That is, if you provide religious material under the statute, you're exempt from prosecution. That exemption renders the statute clearly a content-based restriction of speech that is undoubtedly unconstitutional for that reason. It would be as if the draft card statute provided that no person may destroy a draft card other than as religious expression. And that would clearly be unconstitutional, despite O'Brien, and I think that's ultimately the way the case will be resolved, which leaves nothing resolved, by the way.
Thank you, Ann, for the kind introductions and for ACS for the invitation to attend the conference today. It's a pleasure to be a part of this panel to discuss an issue of such importance. As Professor Cole and Professor Stone outlined the legal issues surrounding the material support statute, I would like to ground the discussion to show what effect these laws and policies are having on the day-to-day activities for donors and charities, specifically the American Muslim community, and the effect this has on freedom of religion and freedom of association. And I will try to do this in 5 minutes. At the outset, I think it's important to note that tithing, or zakat, is a religious obligation for Muslims and one that we hold quite seriously. In exercising this obligation, American Muslims are active locally and internationally through many activities, including soup kitchens, health clinics, community development initiatives. The federal government's steps to cut ties between terrorism and their funding activities has created overbroad and ambiguous laws, regulations, and policies that are having a detrimental effect on this obligation. And some of that is relating to the material support statute, and some of that relates to some of the policies that have been passed by the Department of Treasury. Now, I believe it's critically important not to just examine the constitutional legal principles at play in HLP, but the larger effect the anti-terrorism financing regime is having. A critical part of this analysis includes law enforcement investigations and intelligence gathering that are occurring and their chilling effect on First Amendment protected activity. I want to give you a sense of just how broad the government's investigation of Muslim donors and charities is. The government has extensively interviewed and interrogated scores of donors associated with charities that were designated or later actively prosecuted. As an example, during the investigation of Dr. Rafeel Dafir, an oncologist and U.S. citizen who ran a charity called Help the Needy to assist orphans in Iraq, over 150 people in the community were questioned about their giving practices. One donor reported having the government review his bank account for 20 years, even though he only gave a $150 donation. It is important to note that Dr. DeFeel was never charged with any terrorism-related offense. But what is even more troubling is the breadth of investigation and intelligence gathering of donors and community members about their legitimate charitable activities. We're talking about mosques and charities that are lawful and have not engaged in wrongdoing and have not been designated. We're talking about donors and leaders being probed about their donations to and associations with lawful entities, all without any suspicion of wrongdoing. What we are seeing is a wide net being cast by law enforcement in the name of counterterrorism. And this goes back to what Professor Cole was talking about earlier in terms of the broad range and scope of enforcement and the current environment that we exist in right now. So these activities are taking place in two contexts. First, by Customs and Border Protection at the border, and secondly, by the FBI. And these stories are documented in a report that we drafted entitled Unreasonable Intrusions. The other way in which donors and community leaders are being investigated appears to be through a framework of the FBI's expanded surveillance guidelines. The FBI's Domestic Investigations and Operations Guide, or the short is DIOGS, provide authority for the FBI to send undercover agents and informants into houses of worship, including mosques, community organizations, without evidence of wrongdoing. The DIOGS also call for the collection of behavioral information specific to racial and ethnic communities. In fact, an example of such cultural behavioral data in the DIOGS, again, actually refers to the tradition of charity that exists in Islam as a basis to collect information. So in practice, what we are seeing is a widespread questioning and interviews that inquire about legitimate First Amendment activity by law enforcement, including questions as which religious institution a person attends, which charity they give to, and where their charity gets its funding. Now, the ACLU has documented these reports of law enforcement targeting Muslim donors in over 10 states, including Texas, Michigan, New York, Virginia, Florida, Louisiana, California, Minnesota, Missouri, and Wisconsin. In these interviews, personal and invasive questions were asked about donations to charities. Now, the resulting chilling effect has been severe. Many donors have stopped giving out of a fear of being criminally prosecuted or having information used against them in deportation proceedings. The fact that to date, 6 Muslim charities have been shut down, a 7th has had its assets frozen, and at least 6 have been raided by Joint Terrorism Task Force has not improved the situation. Another aspect that is frustrating for donors is the narrowly constructed material support statute that limits what types of aid can be delivered to an entity designated as a FTO. Under the material support statute, the only items permitted are religious items and medicine. For many involved in international philanthropy and that assist with humanitarian crises, such an exclusive limitation fails to address the full needs of those they serve. This excludes such basic items and services such as doctors, nurses, mosquito nets, latrines, housing, and perhaps most importantly, water, cannot be given to or transported via a foreign terrorist entity. In parts of the world where the group listed by the U.S. as a FTO controls the territory or the transportation channels for goods and services to reach those in need, the only option is for those in need to go without. These certainly are not the values on which this country was founded. So in order to lift the chilling effect on the community, it will be critical to check the authority of law enforcement to conduct broad-based investigations on legitimate and First Amendment protected activity, and for a humanitarian exemption to be added by Congress. Thank you.
Okay, good morning, everybody. As I was listening just now, this television scene from my youth kept popping into my head, which was from the old Monty Python series. I think I'm giving up my age here, where John Cleese occasionally pops up on the screen and says, "Now for something completely different." And as I heard this very impressive set of well-reasoned arguments, it occurred to me that I'm going to be playing the John Cleese part here, because what I'm going to say is completely different, because I'm going to be endorsing the material support statutes as they currently stand. And the way I want to speak to this issue is not so much, as a constitutional scholar going through the details of the constitutional arguments back and forth, in the case before the Supreme Court, and I will beg off on that, partly because discretion is a better part of valor. These experts know it very well. Professor Cole's been litigating this case since the Hoover administration, and I just read the briefs for the first time last week, but also because I think it is very important for us to focus on why we have the material support statutes and the central role that they play. And I guess the first thing I want to do is just sort of go back to basics and talk about what international terrorism is, not as a scare tactic, but just to make sure that we frame the discussion. And there's several truisms about what international terrorism really is, and that is that it's a national security matter. It threatens our national security, and national security, of course, is a core function of our government. It is potentially very damaging. We've seen the horrendous results of terrorism on 9/11, and given the weapons of mass destruction and the sophistication of terrorism networks that are in place now, we could expect potentially exponentially worse damage in the future. And I guess the third truism I'd point out is that terrorism is fueled by passion, is fueled by a cause, and fueled by a philosophy typically. And that has a couple implications. The first implication, which I think is on exhibit here, is that any enforcement in that area is a potentially constitutionally tricky matter. And because you're enforcing at the intersection of a cause and conduct, expressive conduct and criminal conduct. But the second implication of this passion, this cause, is that terrorism tends to be very difficult to prevent with traditional deterrent methods. In other words, our criminal process is based on the idea that if you put someone in jail for a long time, that the next person who considers doing what the first person did will be deterred from doing that. That doesn't work with suicide bombers. It doesn't work so with people who are truly impassioned by their cause. And as a result, as David said, the focus has been and continues to be in the counterterrorism arena on prevention, on interdiction and prevention. And that's what we've seen. Those have been the watchwords since 9/11. The implications of that, of course, are the myriad changes across the U.S. government that we've seen and that have kept Professor Cole busy and prolific over the last 9 years, from the changes to the FBI's, the enhancements to the FBI's investigative capacity to the enhancements to surveillance capacity for the intelligence community, et cetera. But it's also had implications for the mission of the federal prosecutors. And federal prosecutors have been tasked with, and I think have answered the call, to use criminal charges not simply as a means of prosecuting for completed acts, but as a means of disrupting and preventing terrorism. And we've seen that in a number of ways. We've seen them use completely non-terrorism charges against terrorist suspects just to get them off the street, be it visa fraud or mortgage fraud or marriage fraud, false statements and the like. But also, and I think most pertinent to this discussion, we've seen prosecutors use and creatively and aggressively use those statutes that are designed to go after terrorism or the terrorism process short of the successful attack and against the network, the support network and the infrastructure of terrorism, and those are the material support statutes. Won't get into the details about what those statutes are, but there are a number of them that go after material support for terrorism, but the big gun, the most useful statute for prosecutors is 2339B, which as I think we all know, says that the Secretary of State has the authority to designate a foreign terrorist organization if it is a foreign organization, engages in terrorism, and that terrorism is a threat to the national security. And then if somebody provides material support to that organization, that person is subject to up to 15 years in jail. That statute has been tremendously useful. Before 9/11, but particularly after 9/11, I think I saw that there have been about 150 cases brought under that provision. A number of them very traditional terrorist support cases like money to Al-Qaeda or arms, weapons to the Tamil Tigers and others. But also we've seen a number of cases which have prosecuted and convicted people for support like services, providing satellite transmission services to Hezbollah TV station. We've had cases involving, obviously, training for terrorism, helping to get immigration papers for terrorists and the like. So we've seen the use of this statute across the board. And it's absolutely vital that the government have the ability to go after material support for a terrorist organization, and there are three main reasons. One is, obviously, by doing that, you degrade the operational capacity of a terrorist organization. It makes it less capable of doing its job. Secondly, and related, anytime you take off a person who's a money man, who is providing personal assistance, whatever, that helps to disrupt the operations of a terrorist organization and potentially derail a planned terrorist attack. And then the last thing it does is whenever you take that person out of the mix, that throws off the plans of the terrorist organization. They then, if it's a money person, they have to go somewhere else to get the money. If it's communications assistance, they got to go somewhere else to get that assistance. That tends to expose the organization. They're not able to use their traditional protected methods of business. They have to go outside of that, and then that's when we're able to detect them more easily. So these tools have been vital against the terrorist organizations and have been vital also and are equally important against those organizations that have sort of a mixed operational purpose. The Hamas, Hezbollahs, those organizations that have a terrorist aspect but also a humanitarian aspect. And we've heard some of the reasons why it's important that we dry up resources to those organizations as aggressively as we do the Al-Qaedas, which are the more straight terrorist organizations. You heard one reason, which is fungibility of resources. Resources go into the organization, no guarantee they're going to remain on the humanitarian side. They could easily shift over to the terrorism side. Also, whenever you do something that improves the reputation of the terrorist organization, it's going to be harder to delegitimize that organization in the eyes of the world, in the eyes of the public where they live. It makes it easier for them to recruit adherents, get support, have safe houses, this kind of thing, if they're seen not only as a terrorist organization, but as a benevolent organization out among the people. So it's important that we starve organizations across the board of these resources if they are a terrorist organization. And I get it, that means that there are unfortunate situations where benevolent assistance ends up being impeded or prohibited. And that is an unfortunate aspect of this, just like it's been an unfortunate aspect of embargoes that have been placed since time immemorial by our country on foreign countries, which we consider a national security threat. But that's the way you starve a terrorist organization of resources and credibility. Very briefly, let me just answer one question, which is, well, what would be the effect if you didn't have those statutes? Well, clearly we'd be very handicapped in our ability to go and prevent terrorism by attacking the infrastructure. But what if there was a specific intent element? And this is one of the main points that Professor Cole has focused on very effectively. And that does sound reasonable at first blush. Shouldn't a person only be put in jail for sending resources to a foreign terrorist organization if they really intended to promote terrorism as opposed to promote peacekeeping? Well, there's several responses. One is that's not constitutionally required, and that's a very different situation than what we had in McCarthyism and in the Scales case. But also, if you do that, for all the reasons I just stated about how resources are fungible within an organization, you're going to allow a lot of resources to go to these organizations, which will then enhance their ability to carry out terrorism. In addition, it would be tremendously difficult to prove up a material support case if you had to prove specific intent to promote terrorism, because most people are not going to be stupid enough to allow evidence out there that says, you know, with a check to a terrorist organization in the memo line for your terrorist activities. It's going to be very difficult to prove that up, and that's a very practical concern. So, in conclusion, while I think the arguments on both sides are strong, I think there are some worst-case scenarios that are very difficult for the government here. I agree with the government and its position in the case in the Supreme Court. But as I said at the outset, the enforcement of counterterrorism the enforcement in the area of counterterrorism is fraught with difficulty because it is at the intersection of expressive conduct and criminal conduct. As a result, it's important that we scrutinize it, important that we sort of regularly re-examine what we're doing, and I think this is a good example of that effort, and I appreciate you doing it. I appreciate you inviting me to contribute in my small way.
Thank you. Thanks to all the panelists for the opening remarks, and thanks especially to Ken for playing the John Cleese role, as we shall say. Having been on quite a number of Federal Society panels in my time, I know what that feels like, and it's a good way to sharpen the mind. Mm-hmm. So let's jump right into some questions. David, I can't resist asking, what is your response to Ken's argument about why a specific intent requirement would tie the government's arms behind its back.
Well, there are a couple of responses. First of all, there is another statute called 18 U.S.C. Section 2339A, which makes it a crime to provide material support to specific terrorist acts. And that does require a showing of intent, a showing of a nexus between the support and the terrorist act. And the government has obtained many convictions under 2339A. So it's not impossible to obtain a conviction. You don't have to have an admission from an individual in order to get a conviction. You get convictions based on circumstantial evidence and the like. Conspiracy statutes require proof of intent to further the illegal act that is conspired to be engaged in. And yet every day we see people convicted for conspiracy to engage in X, Y, and Z. So, it certainly is a lot easier not to have to prove intent. But it would also be a lot easier if you could just make it a crime to be Muslim, or make it a crime to be Arab, or make it a crime to be a member of any group that we put on a list. That would make it easier too, and it's harder to prove material support than it is to prove that a person is Muslim or Arab or a member of a prescribed group. But we recognize that those are too broad. And I think that at the end of the day, there isn't very much distance between making it a crime to be a member of such an organization, which the government says it couldn't do, and making it a crime to provide any sort of support, even support in the form of pure speech. Because then what's left of the right to become a member? I mean, if you could be a member of the American Constitution Society, but you couldn't support it in any way, shape, or form. You couldn't pay dues. You couldn't make a voluntary contribution. You couldn't speak on its behalf. You couldn't write an op-ed on why it's an important organization. What would be left of the right to be a member of the American Constitution Society? So yes, intent is sometimes difficult to prove, but that's what the Constitution requires, the Supreme Court said in the Scales case and its progeny. And it seems to me that's what it ought to require here, particularly where you've got a statute which targets not just funds, but pure speech, providing advice, providing training, writing op-eds, writing amicus briefs. At least when you're talking about pure speech, you should be required to prove something that shows the intent to further illegal ends.
Ken, just before we move away from this specific conversation, I'd be curious to hear whether you could identify maybe a specific case that in which you think the government would have been challenged in trying to prove specific intent, because most of the ones you identified did sound as if it might not have been quite so challenging. So maybe a particular one that would have been problematic for the government to prove specific intent. And then the second question, which is a little bit related, is even if you're not willing to think about the possibility of amending the statute to include a specific intent requirement, what about a couple of the other reforms that have been suggested, including expanding the definition of humanitarian relief under the statute?
As that last point, I think that's a line drawing issue. Of course, now if you were to include a broad exemption for humanitarian relief or assistance, that then raises the concern that I discussed earlier, which is if you have an organization that's active in a particular area, you give that organization, the terrorist organization, humanitarian assistance. They then provide that to their people. They then generate more loyalty among their people. They then get more adherence to their cause, and that bolsters their ability to carry out terrorism. So I think that's probably why Congress drew the line. I'm not sure what sort of debate there was about that particular addition of humanitarian assistance, but that, I imagine, is why Congress drew the line short of that. In terms of specific intent, the reason Professor Cole cited 2339 and said that is a provision that does require specific intent, and that's true, it does. But in fact, it was the inadequacy of 2339 that led to the passage of 2339A that led to the passage of 2339B without that specific intent. And instead, 2339B just says, look, if this is a foreign terrorist organization, you know that it is one of the designated organizations, or you know that it is involved in terrorism, and you provide material support, that's it. That's all you need. And so that actually was the very genesis and reason for that statute. In terms of the proof problems of requiring, well, let me step back. And yes, we have gotten convictions for 2339A, and you can think of a lot of the classic situations where, in a number of the cases recently, where we've stopped threats here in the United States, and these people are, in the course of planning, they are providing Confederates with explosives, this kind of thing, or they're at a training camp, an Al-Qaeda training camp, then it's pretty clear that you can prove specific intent. Where it's not so clear, though, is through the charitable situation, or where somebody is providing resources from a distance, and it's an organization like Hamas or like Hezbollah, where it's easy for the defendant to say, no, I really intended my money to go to the hospital construction. It would be very difficult in many of those cases, if not most of those cases, to prove out specific intent.
Okay. Akhil, what differences, if any, have you seen in the Obama administration's response to these questions?
I think probably during the Bush administration, there was difficulty in actually even discussing this issue. I think it was during a time that was shortly after 9/11. I think as Professor Cole said, I'm trying to remember the quote that he said, I really like it. It was the paradigm of prevention that existed at the time. And there was not a lot of progress on this. During the Obama administration, I think there has been more of an opportunity to actually have discussions on this issue, but still I think there is some frustration in actually moving and curing what is a lot of frustrations that both the humanitarian sector, in terms of how to actually navigate this arena now, especially the American Muslim community. I would like to say, though, that President Obama did make a commitment last year, in June of last year, about the hurdles to charitable giving for the American Muslim community. So we've actually been trying to work with the administration to make it easier for people to tithe. But at the same time, I think there are many different advocacy organizations that have been working on this issue and have experienced a lot of frustration, especially during Patriot Act reauthorization in the fall, about making specific tweaks on this issue. Part of that is a political issue as well.
Mm-hmm. And Jeff, tell us a little bit about what you see as the distinctions between kind of the government's restrictions today, like the material support provisions, and past attempts during other eras of the government to crack down on protected speech during times of national emergency.
Before I do that, I just want to make a comment about some of the things that have been said. David has focused a lot on pure speech. You've heard that phrase repeatedly. As David knows, I don't think that's a useful concept, and I think the Supreme Court abandoned it in the 1960s when it decided it wasn't a useful concept. It requires distinctions among things like giving an oral speech and, say, picketing or marching or parading or burning a draft card in opposition to the draft. And so basically I think the court recognized that the concept of pure speech, which was very short-lived in the court's doctrine, really doesn't help define very much. And one way to isolate that is to ask the question about giving. Giving money is presumably not pure speech. So I wonder whether David would make the same arguments about the constitutionality of the statute insofar as it applies to the giving of money to these organizations as he makes with respect to the pure speech participation in the organization. To take the point about the ACS, I would think that a law that prohibited us from providing financial support to ACS would be highly problematic from a First Amendment standpoint, and we would be very reluctant to say that's okay, it doesn't involve pure speech. And the question then is there really anything to this pure speech argument, and does it really require David to say the same thing about giving? And that poses a much greater issue with respect to the government's concerns about these organizations. Saying you can't give speech to the organization in terms of advice or whatever has a relatively modest impact on the kind of concerns that Ken has. Saying that you can't give money has a much larger impact. So I think that's worth exploring further. Also, I think with respect to Akhil's point, it's important to separate charitable giving from political giving. Political giving is speech. Giving money to charities so they can do good works with that money is not speech. It's just giving money for the purposes of enabling them to do good things. It's admirable activity, but it's not necessarily protected by the First Amendment at all. And so it's not clear that restrictions on charitable giving, which are not designed to support speech activities, really has anything to do with the First Amendment. Finally, to come back then to Ann's question, I think there are significant differences in the way government responds to national security concerns in different eras. Some of that is due to the reality differences, and some of it is due to what we allow the government to get away with. So, for example, in World War I, the primary efforts the government made to interfere with speech had to do with basically preventing people from criticizing the war in the draft. In the Espionage Act of 1917 and the Sedition Act of 1918, the government effectively made it a crime for anyone to criticize the government in its undertaking of the military effort. And the reason the government did that was perfectly obvious. You don't want people to turn against the war, which you believe it's a good war. So you essentially control public discourse. And in World War I, they were able to do that. And if you're the governor and you're able to do that, it's going to be very tempting. By the time you get to World War II, there had been a lot of rethinking about that issue, and I think it was pretty clear that the government would not have had the same leeway to do that. But in any event, World War II was a popular war, so with the exception of a few really sort of off-the-chart dissidents, there was very little criticism of the war during the Second World War. But the primary concern that seemed to affect the government was the concern about internal subversion and espionage combined with a rampant racism, which led to the internment, which was probably the primary civil liberties violation of the Second World War, the internment of Japanese Americans. And that, again, was largely political. It had some small amount to do with the real national security concerns, but I think we now know historically that it was much more about appeasing those who wanted Japanese Americans interned for their own either racist reasons or economic reasons or whatever, rather than because of any true military belief that this was necessary to the security of the United States. Today, I think Ken and David both well identified the issue. It's prevention. In a world of terrorism, the primary concern of the government is not with the American people turning against the United States. That's not really the key issue. And the issue of internal subversion and espionage is not the non-issue, but it's not the primary one. The great issue here is how do you prevent an individual or a group that has the capacity to wreak havoc on society, as it did in 9/11, and it has the potential to do even more so, from being able to do that. And there, because you can't really deter, for the reasons Ken gave, the need to ferret out plots that could have devastating consequences becomes much more important. And that's clearly the way in which the government has attempted to deal with this issue. And that explains, in some sense, the temptation to engage in torture, the temptation to engage in very intensive surveillance, and the desire to cut off aid to these organizations to weaken them before they can have the resources to attack. Mm-hmm. So I think that's the way in which we see it playing out today.
We've been focused mainly on the First Amendment implications of the material support laws. They also, of course, raise very serious due process questions, as do as does the designation regime that is very closely related to these provisions. Let's talk a little bit about that. David, do you want to say a little bit about your litigation on this issue?
Sure, but first I have to answer Jeff's question.
Okay.
In the Supreme Court, our case involved pure speech, and I know Jeff and I just disagree about the relevance of that term. I think it still has relevance, and I'll suggest why. And so we did not, in the Supreme Court, seek to challenge the criminalization of providing money to designated terrorist organizations. In the lower courts, we did challenge both. And I think from the standpoint of guilt by association, from the standpoint of the right of association, I'm not sure there's a meaningful distinction between supporting the ACS by giving it money or supporting the ACS by speaking out on its behalf. Both are associational activities. If you're being penalized because you gave that money to ACS or because you spoke for ACS, that's guilt by association, and it shouldn't be permitted without some showing of specific intent. We've made that argument with respect to money in the lower courts. but lost and chose not to pursue that in the Supreme Court. Why I think pure speech is different is that I think Jeff's right that the court has used to sort of treat speech and conduct as really sort of diametrically different concepts, and then recognize that in fact much speech comes in the form of conduct, and that in fact that distinction is easy to deconstruct, and therefore some conduct, when it's prohibited because of what it communicates, raises the same concerns as the regulation of pure speech does, as in the flag burning cases. The court held the prohibition on flag burning, even though its conduct is subject to stringent First Amendment protection because the purpose in regulating the conduct is what it expresses. But the relevance of pure speech is that when what you're doing is supporting only through speech, telling someone how to bring a human rights complaint in Geneva, that's only speech. There is no non-communicative element of what you're doing that the government could say this is conduct, therefore we're not regulating speech, therefore you shouldn't subject it to stringent scrutiny. So when the government seeks to criminalize what I would characterize as pure speech, then I think the conduct argument is not relevant. With respect to this is what we've talked about so far is one set of the constitutional concerns that arise from this practice. But there's another set, and that is the due process concerns that arise with respect to the designation of organizations in the first place. How are these lists constructed? How do you get on a list? How do you get off a list? And looking into that, it's really quite remarkable. And I'm involved in a couple of cases here in the United States in which district courts have held that the process for designating charities here is unconstitutional. Why? Because the process basically is that a branch of the Treasury Department, the Office of Foreign Assets Control, just puts a group on a list. It freezes all that group's assets. It never provides a statement of reasons. It's required, if the group is in the United States, to provide it with the unclassified evidence that it relied upon, but it's not required to say how that evidence is relevant to what the organization is alleged to have done. And so when you're representing one of these groups, you say, well, we think our group's not a terrorist organization, shouldn't be on the list. The government says, well, we think it is. We're not going to tell you why we think it is, but we think it is. But you're free to defend yourself. What do you do? And then they say, well, we'll give you the unclassified evidence that we relied on, and they give you a pack of papers like this, and 95% of the pieces of paper don't even mention your client, and you're supposed to somehow connect the dots and intuit why the government has charged your client, and then seek to defend on that basis. And that's only with respect to the unclassified evidence. The government's also permitted to, and does in each instance, rely heavily on classified evidence that it doesn't provide to the designated entity, that it doesn't provide any summary of to the designated entity. And so you've got a process in which the government basically has a blank check to put whoever it wants on the list and makes it impossible for anyone to defend themselves. And then they've exported this to the rest of the world through the UN Sanctions Committee, where the UN Sanctions Committee had a process in which any country could nominate a person to be on the list or a group to be on the list, and unless the UN Security Council vetoed that, the person would automatically go on the list. Courts around the world are beginning to recognize, and then every country in the world would be required to make it a crime to support these groups. Courts around the world are beginning to recognize that this is not fair. The European Court of Justice held that this process violates the European Constitution. The UK Supreme Court held that this process violates the European Convention on Human Rights and UK law, which adopts that. And I'm hopeful that our own courts will continue to recognize that this process also violates due process.
Akil, do you want to say a little bit about the impact on the many organizations you work with of the due process limitations of the designation statute?
Yeah, I mean, Professor Cole touched on it a little bit as well, and one of the things that's really kind of invasive and affecting the community is the way in which the assets of organizations are frozen. And Professor Colligan touched on that a bit about the freezing of assets of specific organizations. And in the Kind Hearts case, I believe the assets were frozen for over 3 years without any charges being brought forth. And in that case, I think they've recently said that there were some due process issues, to say the least, and now that's currently remanded. And what they've said in the case, though, is that the government does have the ability, and hopefully if I'm incorrect, someone can straighten me out, but the government does have the ability to freeze the assets of an organization and can later provide evidentiary information to show why that was acceptable. So what we've kind of touched upon today are the myriad of issues affecting anti-terrorism financing. From the constitutional perspective of what's going on with HLP, we've talked a little bit about the effect with the community, and we've also talked about the other tools that the government has in place. And the pendulum is starting to swing. I mean, these laws, are these laws necessary? Yes. Is anti-terrorism financing an issue? Yes. But the impact it's having on the community is pushing people away who can be an asset. And that's the way we have to start thinking about it. If you want to start thinking about it in the national security frame, you have to start involving these people in the process of assisting. And currently that's not being done.
So we'll let Ken have the last word before we open it up for audience questions. What's wrong with the little due process?
Man, that's a loaded question. I think there's a little due process out there. I don't know that you really want an answer to that question.
No, I actually do. Seriously, you gave a very reasonable response to the other ones. What would be the downside from the government's perspective of increasing the due process protections around, without getting rid of the laws?
Right. Well, I mean, there's so many ways you can answer that, and there's so many permutations. Let's just take the one example that Professor Cole just raised about the litigation of the designations and the classified information. And I frankly am not an expert in that process, but that's not unlike many processes throughout our criminal justice and our system and our intelligence operations, where an individual is aggrieved one way or the other by something that's been done by law enforcement, the FBI or the intelligence community agency, wants to challenge it, but that action was undertaken based on classified information. So in this case, you're talking about the designation of an organization or individual as a terrorist, and if we're talking about international terrorism, very good chance, if not overwhelming likelihood, that some of the information that led to that action is classified, is based on sensitive sources and methods, a FISA wiretap somewhere or a well-placed source somewhere else, and that cannot be shared. It just simply cannot be shared with the agency or the organization itself, because obviously that would disclose the sensitive sources and methods. Same things happens with FISA. If you want to use a wiretap that you got off of FISA, Foreign Intelligence Surveillance Act, which is the act that allows intelligence wiretaps, for intelligence operations. You want to use that wiretap in a criminal case. The criminal defendant can challenge the legality of that wiretap, but the judge actually looks at the application and the documentation that supported the securing of that wiretap authorization and does so without the defendant being there, which seems, very bizarre until you sort of think back and think, gosh, the whole basis for getting that wiretap was classified information, and if you had a mechanism where that information got laid out publicly, whenever a defendant wanted to challenge its introduction into court, then you would be disclosing lots of sensitive information. And obviously we could argue forever about different ways that process could be tweaked in order to protect classified information but still provide due process. My point is this balancing between the protection of our intelligence operations and the absolute need for due process as well as transparency to the greatest extent is a tough one, and it plays out in all these areas.
Thanks. Okay, so let's open it up for questions. Yeah.
Thank you.
The people with the mics are in charge.
First, a quick comment. I wish that the government would stick to its belief that money is fungible when it comes to faith-based funding, among other things. Secondly, a question for Ken Weinstein. I also appreciate your being here and giving us an alternate view, which, anyway, I'll get to the question. If we accept for the sake of argument that there is a need for this very expansive prosecutorial discretion in these cases, and that there's a need for this very broad law. How do you deal with the inevitable abuses? I mean, you made some sort of parenthetical remarks about, yeah, we're going to deter some innocent activity, we'll break a few eggs, but it's much more than that. We're not just going to deter innocent activity, we're going to prosecute innocent people. Yes, a specific intent requirement makes it harder to convict, but it's supposed to be hard to convict people of serious felonies. As Professor Cole says, there's a blank check for putting people on the list, and you're essentially suggesting that we should have a blank check for prosecuting people, and this only works if we can trust people in the State Department and people in the Justice Department never to make mistakes and never to act in bad faith. And I'm assuming that you're not advocating that. And so I want to know where you see the possible checks on prosecutorial abuses in this system.
That's a good question, and thanks. Let me once again sort of universalize the question in the sense that, what's the check against abuses? There's always going to be the potential for abuses whenever you vest in a human being the discretion to decide to take law enforcement steps, to exercise criminal justice tools. So this is not to minimize your question. I'm just saying.
That's why we design criminal laws narrow, and this is a law that you're saying can't be designed narrow. So forgive me, but I don't want you to universalize the answer. It's not a universal question. It's a very specific one about this specific statute and the way these laws are being used.
Now, I'm not saying that you can't tailor the law more narrowly. You certainly can. You make much more narrow, but then you'll increase the threat to national security. So there's a balance there. And so the question is this. If we want to starve terrorist organizations that propound terrorism and will not renounce terrorism and make them go away, then the way to do that is to use tools aggressively to prevent them from getting the resources they need. I mean, it's a very simple calculation. The problem is, you're right, there are going to be activities, some of which are in play here in this case, in the case before the Supreme Court, where you think, gosh, in theory, we'd like that to happen. But the same thing goes with embargoes, where we have to make a decision that, gee, this is a pariah state, and we've got to delegitimize that state because it's a danger to the world community, so we're going to embargo any interaction with that country. That means there might be people in there who could use food, and you could use training and use education that we're not providing to them, and that is bad. I mean, it's a shame in one sense, but there is a broader purpose. And that's the calculation that Congress made. And absent a constitutional infirmity, absent something like the Scales case, where what Congress did is actually prohibited membership, prohibited association. This doesn't prohibit association. You can actually, this allows one to be a member of a foreign terrorist organization. You cannot provide material support. Professor Cole would say he doesn't see how you can be a member and not somehow support it. The thing is, if you look at the definitions in the statute, they require some affirmative step to provide support to that organization. That is what's outlawed, not association.
Ken, if I can follow up on that. I was a little puzzled by your comments about the due process issue. And it's really reflective of the larger set of questions. I mean, it seems to me that you're right that we want to be careful about unduly sacrificing national security issues. On the other hand, it seems to me the argument you're making is that we should be largely indifferent to the fact that in order to protect national security issues, we may be needlessly casting off constitutional or fairness issues. So, for example, on the question of designation, right, it's certainly true that there may be instances in which the proof necessary to justify designation involves national security secrets, and that you wouldn't want the organization that's being listed to have access to that information. There must be situations where that's true. On the other hand, I would guess that in most instances that's not the case, and even where it is the case, it's perfectly possible to have a procedure in which the organization doesn't, in fact, even necessarily participate in the designation decision, but where there's a detached and neutral and independent entity that makes the decision about designation. And at the very least, it seems to me that there should be both the equivalent of a judge who decides on designation, rather than someone who works for the DOJ or the State Department, the Defense Department, or Homeland Security, and that in the same way we have FISA, and that there should be a limitation on the ability in that setting to claim national security to those specific instances where a judge finds there's persuasive justification for allowing the reliance on that information without disclosing it. But to a judge, you pretty well disclose it anyway. So I just don't see why there's a necessity to resist the notion that there are steps that the government should take, either constitutionally required or otherwise, that would strike a better balance than the one that you're arguing for.
Well, can I respond to that?
Yeah, go ahead.
First, when you talk about taking the designation process and putting it in the hands of a judge, then we're talking about, executive authority issues, and I think it takes this conversation sort of to a different area. But to sort of take your point to mean, look, there are other ways of striking this balance between the need to protect classified information and the provision of due process or process generally, maybe not constitutionally required, but process generally and transparency. Yes, I agree. There is. There's no question. And actually, I could draw a parallel to what you're arguing, that function should be vested in a court. I mean, up until 1978, the authority to get a national security wiretap was vested in the executive branch. And with FISA came along, the statute, and that created the FISA court, and now the executive branch has to go to a court in order to get authority to do a national security wiretap. So there was a change in the process. In fact, it actually brought the judicial branch in, which is akin to what you're suggesting. Mm-hmm. My point, though, is not to argue against any particular sort of reframing of the process. My point is only that in all these areas, there is a balancing that has to be done. And you can come up with a myriad ideas of balancing it, as you say, better. Maybe making sure that cleared counsel for a group is able to see all the classified information, what have you. There are ways of balancing it better. My only point is that it's a never-ending debate in all these areas, this one included. It's healthy to have the debate, but you've got to understand there are very real issues other than the government just sort of wanting to jealously guard its prerogatives at play.
Okay, let's get to some more questions. Yeah. Here.
Thanks so much. I have a question with regard to the fungibility of money theory or something that comes out of that. Mr. Weinstein, how can you claim that by providing funds to a hospital that has no affiliation with a terrorist group, but is just in the territory where a terrorist group controls that area, how is that providing material support to a terrorist organization as opposed to collectively punishing the entire civilian population? And I think that's really what's problematic from the charitable sector's perspective is you think you're starving a terrorist organization, and I would argue you're starving a civilian population, which I don't think is in our national security as a policy issue, but it's also kind of a cruel policy. So that's the first thing. How did you differentiate? And that's where specific intent, I think, does come into play significantly. And second, to Professor Stone's comment about charitable giving isn't protected, it couldn't be political speech. What if you had a scenario where individuals who politically think that it is the Darfur conflict, and they think that what's happening in Darfur is a human rights issue is wrong, and it's their political viewpoint, and they would like to provide funds to assist women who have been raped by the strife in Darfur? How is that not a political statement, and why shouldn't that be protected by the First Amendment?
I'll take it first. No, the scenario you posit is the toughest one because you're right. This is money going to a hospital. We want people to have hospitals. That's a good thing. Now, if somebody provides money to a hospital that happens to be in an area where the foreign terrorist organization is active, that's not against the law. It's providing money to a foreign terrorist organization that would then set up a hospital with it. And, this is a policy decision, and Congress made the policy decision. As I said early on in my remarks, I get it. I see there's a problem there, but as a matter of sort of rational legislation, Congress said, we see that there are going to be some downsides to this because some people are not going to get assistance they otherwise would, but for the reason that we want to starve that organization. And just the real life, I guess the argument for the government would be if the terrorist organization provides those funds to the hospital, the people at the hospital, the people who are served at the hospital are going to then have gratitude toward the organization. It's going to enhance legitimacy of that organization. maybe their terrorist bombers would get treatment there, but also that money might go into the terrorist organization for the purposes of that hospital, but then get diverted over to bomb making. And so, and which is exactly what Solicitor General Kagan talked about up in front of the Supreme Court. And my take on the argument there was, I think the biggest problem is the sort of harsh reality of the application of these laws, which is that there are situations like that where everybody would think that's a good thing, but it's not going to be allowed for a broader policy and counterterrorism policy reason.
Yeah, so my view about charitable giving is that the reason the First Amendment protects money is because the money is being given for the purpose of enabling expression. That's the connection to the First Amendment. And spending or giving money otherwise is not a First Amendment activity. So if someone gives money to an organization for the purposes of helping to give medical care for the homeless, again, that's admirable activity, but I don't think that's protected by the First Amendment because there's no expressive element to it. Now, there's an implicit expressive element in everything we do. So, you know, coming to Washington to go to the ACS meeting is expressing in some way support for the ACS, but we wouldn't call that getting on a plane First Amendment activity. And choosing which charitable organization to give money to suggests in some implicit way that I care about the homeless, and therefore there is some implicit expression of the fact that I care more about the homeless than I do about a musical organization, because they make the choice of giving money to one rather than the other. But in those circumstances, I think the fundamental element of what's going on is that you're giving money for the purposes of supporting an organization that's doing good, but what it's doing is not speech. And therefore, I think the charitable giving is not protected by the First Amendment.
I take a slightly different view on that. I think that there are lots, and Jeff is right, there are lots of things one can do for expressive purposes. You can assassinate the president for expressive purposes. You can give money to a charitable organization for expressive purposes. So the mere fact that you do it for expressive purposes doesn't mean that it's protected by the First Amendment. I think what the court has said is we look not at why you did it so much as why the government is regulating it. And if the government is regulating because it's concerned about something that it expresses, then, or the expressive element of the giving, then it would be a First Amendment speech issue. If the government's interest is unrelated to what it expresses, then it would not. And the other thing I'd say, just to repeat what I said earlier, is I think there is an associational issue, whether or not there's a speech issue, when the government starts saying you can give money to this group, but you can't give money to this group. That's imposing guilt on the basis of your associational act of providing money.
In my view, Ann Beeson narrowed in on two extraordinarily important questions, somewhat uncharacteristically, perhaps because she's the moderator, she wasn't able to cross-examine and push them. But one was the sort of due process piece of this outrageous idea of a unilateral designation of somebody or some organization as a terrorist organization without any due process rights. But that seemed to be pretty well discussed. The one that wasn't responded to other than one small comment was the question about what's the difference between what happened in the Bush administration and what happens in the Obama administration. And that small comment was, well, we're discussing it. It should perhaps be pointed out the Counterterrorism and Effective Death Penalty Act was enacted under a Democratic administration, the Clinton administration. It should be pointed out that perhaps the prosecution of these cases is being done still by a Democratic administration, the Obama administration, that whether or not it's the right to assassinate American citizens or other issues of some questionable historical legality, the Obama administration has been carrying these things on quite unmindful of their liberal designation. I'm wondering if the panel might want to discuss that piece of it.
I wrote a piece for, I think, for Mother Jones before Obama was elected, saying, you know, don't expect massive changes if President Obama gets elected. And that was in part in this area, and that was in part based on my having been engaged in this kind of litigation under President Reagan and the first President Bush, and then when President Clinton was elected, I thought, oh my gosh, now finally we'll have some reason coming out of the executive branch, and they will settle some of these cases, and et cetera, et cetera. And in fact, that was not the case at all. It was President Clinton who supported the Anti-Terrorism and Effective Death Penalty Act. It was President Clinton who brought the appeal of the LA 8 case, which involved going after Palestinian immigrants for their political associations to the Supreme Court. And I think that, you know, the reality is that once government officials get into office and are exercising these powers, they trust themselves, and their sense is, well, look, you know, some of these tactics are quite useful, and we're going to continue to pursue them. The other reality is that many of the people who are pushing the particular cases are career people or political people hired by the prior administration who know who sort of have their life invested in these cases. The people who come in at the top don't often have the time to invest in really getting down into the weeds sufficiently in order to turn them around. And then the third point is that politically, whether you're a Democrat or a Republican, and we've seen this very clearly in this administration, the tough thing to do is to stand up for constitutional rights when it's on behalf of people accused of terrorist ties or terrorist associations or terrorist support of any kind. And so all of the political pressures, whether you're a Democrat running out of fear or whether you're a Republican feeling that this is one of your strong issues, all the political pressures go on one side, which is why I think litigation is critically important in this area, and I think public education is critically important. And but your question suggests some disappointment with the Obama administration, and certainly in this area there has not been. I wouldn't say that across the board there's been no distinction at all, but in this area there's been no real difference between the Obama administration's positions on these matters and its predecessors.
We're out of time, so let's thank our panelists and thank all of you for coming.